Hi, I'm Jennifer Brown, editor of Canadian Lawyer In-House Magazine, and today I'm here with Frank Walwyn and Nadia Chiesa of Weirfolds LLP. In this edition of the Weirfolds Quiz, we're discussing the complexities of litigating in offshore jurisdictions, in this case, the Caribbean. Frank, let's say you have a client in Ontario who is a director and shareholder of a company called Caribbean Energy LLC. It's based in Nevis, and it's an oil exploration company. The company's subsidiary discovered some significant reserves in Belize and started making profits. The management and directors shut your client out. She wants to bring an oppression action against them. Since she lives in Ontario and the directors live in Ontario, can she sue here?
Jennifer, I hate to sound like a lawyer, but it depends. Perhaps a better question is, should she sue here? In offshore multi-jurisdictional business disputes, the most important question that you and your client will have to answer is where you should sue, where you should commence a claim. There's so many jurisdictions in which you can commence a claim if it's multi-jurisdictional. One of the considerations, of course, is going to be whether the court in the jurisdiction that you choose will claim jurisdiction over the cause of action. What you will find very often is that a defendant will, if faced with a claim in a jurisdiction, say that it's not the appropriate forum in which the claim should be brought. And so you'll get an application for forum non-convenience. That is, it's not the best forum for the claim. And the court will have to determine whether or not it will claim jurisdiction. As a defendant, you will always look at a claim and say, should I defend? And you may decide to apply to stay the claim on the basis of, as I've said, forum non-convenience. So these are considerations that every claimant, every client, and every lawyer litigating in the Caribbean will look at. The other thing you have to remember is each jurisdiction has different rules of procedure, and some of those can trip you up. If you're served with a claim and you want to deny that the court has jurisdiction, you may actually have to tell the court you've received the claim, file a notice of acting or notice of you acknowledge service, and then challenge jurisdiction. So even though you say the court has no jurisdiction, you may have to file documentation that says, yes, court, we've received the claim, we intend to challenge jurisdiction, but here is who we are and here are the lawyers who will act. In your fact pattern, very likely the claim will have to be commenced in Nevis. Many of the offshore jurisdictions have legislation that say if a corporation is incorporated in that jurisdiction for certain types of claims, that claim must be brought in the jurisdiction. So notwithstanding that you've got defendants who live and work and there are other relationships to Ontario, it is very likely that the claim will have to be brought where that company is incorporated, which is Nevis.
Okay, Nadia, your client gets a judgment against Caribbean Energy, and one of the directors owns property in Toronto. Can she enforce the judgment from Nevis? Or if your client gets a judgment in Ontario, can she enforce it in Nevis?
So I'll echo Frank's answer and say it depends. And again, when you're dealing with multi-jurisdictional litigation, if maybe the second most important question to ask is, can you enforce the judgment once you've actually got it? So Ontario lawyers may be more familiar with enforcing a foreign judgment here in Ontario, so I'll address your second question, whether they can take the Ontario judgment and enforce it down in Nevis. A foreign judgment won't have any direct operation, so you can't just walk in and enforce it in a Caribbean jurisdiction. It has to be registered or recognized by the court there. There are two ways to do this. You can either bring a claim at common law to register the judgment, or Caribbean jurisdictions may have a statute that provides a summary procedure for the registration of the judgment. In jurisdictions that have this summary procedure, your judgment will have to be from a country that's on the specified list of countries. Unfortunately, Canada often isn't on this list. And your judgment will also have to meet a set of statutory requirements. If your judgment's from a country that falls outside the scope of the statute or doesn't meet the requirements, you'll have to bring a claim at common law to register the judgment in that Caribbean jurisdiction. There are certain common elements, whether you're registering a judgment under a statute or bringing proceedings at common law, the judgment has to be final and conclusive. It has to be for the payment of a sum of money. It has to have been issued by a court that had jurisdiction over the matter, and it can't have been obtained by fraud.
Okay, thank you both. For more on the issues around litigating in the Caribbean, please see the December issue of the Weirfolds Quiz.